I'm sorry to interrupt, but
I'm sorry.
I do admire the government's concession of error here, and I appreciate the candor with which you've made it. But given that we just took the case to resolve the right to control issue and not this other theory that you're attempting to develop about fraudulent inducement of even matters of equal value, why isn't the proper result here to reverse? Maybe you have an argument for vacate, but your very able friend on the other side makes a strong point that there was a superseding indictment here that seemed to rely expressly on the right to control theory, and the government didn't present this alternative view until merits briefing in this court.
Two answers to that, Your Honor. Just first, and this actually sort of is an additional answer to the Chief Justice's question, I do think it's important, if this court does decide to send this back or even reverse, how it reverses. And it is critically important to us for kinds of fraud that we prosecute all the time that the court not reach too broadly and impugn, for example, the veterans example I was giving.
So how would you have us write that is my question.
So I think what the court could say is that the kind of sort of what I was saying to the Chief Justice, that the kind of property that is now at issue in these right to control cases, which is the right to control assets without assets necessarily in all cases, as they would have been here, confined to something that's properly understood as property. The right to control assets in a manner that doesn't expose the victim to tangible harm isn't itself something that Congress would have conceived of as property and can be prone potentially to abuses. We don't think it was abused in this case, and that'll go to the second part of your question. But I think that's really all that the court needs to say here. I wouldn't cast any question on—
I think we're all in radical agreement about that. I think the question I'm trying to put my finger on is what we should do with this case.
Okay.
And Mr. Dreeben suggests that the appropriate judgment line is reversed, and that the government shouldn't get another chance to reintroduce what it believes now to be the correct theory, fraudulent inducement, I'll use as shorthand, because it took that out of the case in a superseding indictment. And here we are many years later, and it's the first time it appears as a merits briefing before this court. So why isn't, or maybe you agree that the proper remedy in this case is reversal?
No, I don't agree with that, Your Honor. So if we take the government's, if we're all agreed on the broader interest of this case, and the court's not going to relitigate Shaw and Nieder and introduce some sort of harm concept that it firmly rejected on page 467 of Shaw, and I can get to why that is, then in this particular case, I think it's different from the kinds of cases that Mr. Dreeben is citing. First of all they have made here is a sufficiency of the evidence challenge. And in a sufficiency of the evidence challenge, the question is we compare—
Well, I think that might be, Mr. Dreeben would tell us, because of the way the government litigated this case up until its merits brief in this court. And again, just if we all agree in a radical agreement that the Second Circuit misinterpreted the law, and if we're all in radical agreement that that the only indictment before the jury was a right to control theory, why should the government have yet another chance to start all over again, this stage,
well, Your Honor,
in this case?
First of all, I think that this error could be analogized, although I will acknowledge that it's somewhat broader than the errors in those cases, like the errors in Nieder or Masaccio.
I'm sorry to interrupt, but and I'll stop. This will be my last shot at it. But just take that superseding indictment. Right? Why isn't that a firm waiver of the theories that you wish now to pursue?
Your Honor, I think we clarified that we're proceeding under a right to control theory in order to comply with Second Circuit law. But I think if you read the indictment as a whole, the jury had it in front of it, and in the context of the only thing the jury could have found to satisfy the instructions and to find guilt on the relevant charges in this case. I don't think there has been anything close to some sort of switch of horses, to continue the horse metaphors, midstream here. And if I could get